Register, would you please call the case number? This is IT 95-9 PT. The prosecutor against Slobodon Milković, alias Lugar, Blagoje Simić, Milan Simić, Miroslav Tadić, alias Miro Birko, Stevan Todorović, alias Steve, alias Stevo, alias Monstrum, Simo Zaric, alias Shoria. Very well. Registrar, would we have the accused brought in, please?
Monsieur. Bien.
Mr. Todorović, for the time being, I'm going to ask you to be seated. Oh, perhaps it would be best to give Mr. Todorović his headphone. Do you hear me, Mr. Todorović? This is the presiding judge speaking to you. Please state your name, your first name, your profession, your age, and your domicile that you had, the domicile you had before your arrest.
My name is Stevan Todorović. I was born 29 December 1957 in Bosanski Shamac. My address is in Donja Slatina, Bosanski Shamac municipality.
Your profession, please.
I am an engineer of machinery.
Thank you. You may be seated. I would like the representatives of the two parties to identify themselves. First of all, turning to the prosecution.
Your Honours, please, my name is Neiman and I appear with my colleagues, Ms. Patterson, Mr. Miklic and Mr. Enik for the prosecution. Ms. Enik for the prosecution, Your Honours, please.
Défense.
For the defense.
Mr. President, I am Goran Nešković from Doboj in the Republic of Srpska. I have been assigned as a counsel to Mr. Todorović.
A register. Is Mr. Nešković is he registered in the bar, and has he given all the official totals? Yes, he has been assigned officially by the tribunal. Do you speak one of the two official languages of the tribunal, Mr. Nešković?
Mr. President, I do not speak one of the two official languages.
Which language do you speak? Perhaps I misunderstood the interpretation. According to the interpretation, it said that you did not speak one of the two languages. I understood that you did speak one of them. One of the two, that is. So you do not speak either of the languages?
No, I do not speak either of the two official languages of the tribunal, neither English nor French.
Very well, neither of the two. All right, then the registrar has placed your name on our list. I make no comments other than to say to you that this may sometimes cause not problems specifically related to your client, because he has a lawyer with whom he can understand things and with whom he gets along well, but there are frequently motions and briefs that are filed with this tribunal, if only by the other party. They're going to come and they will be presented, and that you understand that this is a French-speaking trial chamber. But this is something that you already know. We are here for the initial appearance of Mr. Todorović. Let me remind you that Mr. Todorović was included in an indictment which was confirmed in 1995, I believe, Yes, it was confirmed on the 21st of July 1995 by Judge Vora. All right, 21 July 1995. And we will come back to this, but in which there are already other accused who are already in the United Nations detention facility in The Hague. Mr. Todorović, today this is an initial appearance that you're going to, after certain texts are read, you're going to state before the tribunal whether, in respect of the various charges which the prosecutor has brought against you and which were confirmed in 1995 by a judge, you will plead either guilty or not guilty to each of the counts, and after this we will attempt to see how we can organize the rest of the proceedings, with the difficulty, of course, that in this tribunal now we are going through all kinds of preparatory phases that were specifically carried out in relation to this specific indictment, and which involve 3 other accused who are today being held in the detention unit. Without any further ado, perhaps we could turn to the register and ask the registrar to read the relevant articles in the statute, or perhaps Mr. Neskowicz would care to say something.
Yes, Mr. President. First of all, I have not been asked whether we had prepared for the initial appearance. You realize that I arrived here yesterday. I talked to Mr. Stevan Todorović. However, I was not able to reach I was not able to discuss things with him because of his health conditions. During the process of his arrest in the former Yugoslavia, he received a very heavy blow with a baseball bat over his head. I requested of Mr. Jean-Jacques Heinz yesterday to have an MRI, and this has not been done so far. Some injuries may only appear within 7 days, certain hematoma. Mr. Todorović has complained of headaches and nausea all day yesterday, and I believe that it would not be appropriate for him to go through the initial appearance today.
First, we're going to ask Mr. Todorović's opinion, and then I would like to hear comments from the Office of the Prosecutor. And I will also, of course, hear what my colleagues have to say. Mr. Todorović, would you please stand? You are before an international tribunal. You may have full confidence in this tribunal and say what you wish to say at this moment, and then we will see what has to be done. Mr. Todorović, how do you feel? First of all, would you prefer to speak seating? Because your lawyer has drawn a rather negative picture of your medical condition, or would you prefer to speak while you are still standing up?
Mr. President, if I may sit down with your permission.
Yes, you may, of course, speak sitting down, Mr. Todorović. Would you explain, or first tell us, please, how you feel?
I don't feel well because during the kidnapping, I was transported from Serbia by boat, and I received a heavy blow with a baseball bat over my head. And I still feel a headache, dizziness, nausea, and I have occasional vomiting. And as the attorney Nešković said, I had a visit by the medical doctor, and this was just a superficial examination without any X-ray or any MRI. My apologies. And I still have a scar here in the back of my head. That is a laceration. And there may be a hematoma underneath, and if I have any abrupt movements and if I lean back onto the cushion, I get a feeling of dizziness and nausea and I vomit.
All right, let me ask the register, since we spoke with Mr. Jean-Jacques Heinz about it. I suppose that these examinations have been scheduled. Is that correct, register? Would you speak on behalf of the registry? Yes, if Mr. Heinz is aware of this request, and I'm sure that the MR will not be postponed. First of all, I would like to give the floor to the Office of the Prosecutor and then turn to Mr. Nešković. We have tried to apply the rules in the most flexible way possible. I can recall that Rule 62, as in all legal systems, states that when there is an arrest, there must be an appearance quickly before a judge. And perhaps, Mr. Nešković, if we had not had Mr. Todorović appear today, would now be preparing a motion in which he would state that it was not normal for his client to be thrown into the detention unit in Scheveningen without having seen a judge. Therefore, I think his rights have been explained to the client, but I would like to hear what he has to say. But this was not in order to try to surprise you. Mr. Todorović was arrested when, Mr. Register? Mr. Todorović arrived in the detention unit on Sunday, if I'm not mistaken. Sunday. All right, today is Wednesday. It doesn't seem particularly strange to me for there to be 2 or 3 days to go by before the initial appearance. And it's the time necessary for Mr. Todorović to know how the proceedings are conducted. But we will see if it is possible to continue or not. Let me now turn to Mr. Niemann, or to one of the other representatives of the OTP, and ask what he has to say.
Thank you, Your Honours. Unfortunately, Your Honours, we're not in a position to assist the trial chamber with any of the details of the arrest. We don't know what details occurred there. With respect to the situation we find ourselves in now, the position of the prosecution is that we would be reluctant to see a plea taken from the accused, be it guilty or not guilty, if he has said directly and through his counsel that he is not well. Our concern would be that if he is not well, he is probably not in the best position to indicate to the court his attitude to the charges that are laid against him. Your Honours are rightfully concerned about the issue of an accused being put in detention and not being brought before a judge as expeditiously as possible, and that, of course, is an issue that the prosecution shares with Your Honours. In our submission, Your Honours, the two of the very important components of Rule 62 can be properly satisfied at this stage without the necessity of taking a plea. Firstly, Your Honours need satisfy yourselves that the accused is properly represented by counsel. Your Honours can satisfy yourself of that fact because counsel does appear here today in respect of Mr. Todorović and has made submissions on his behalf. With respect to reading the indictment, which is also an important matter, we would submit, Your Honours, if counsel for Mr. Todorović were to give you an undertaking to read the indictment to him at the very earliest possible time, Your Honours could be satisfied that he has had read to him the indictment in a language that he understands. If counsel were prepared for the defence, were prepared to give that undertaking to Your Honours at this stage, then two of the concerns that are dealt with in Rule 62 would be, in my respectful submission, disposed of. That wouldn't preclude, Your Honours, a formal proceeding of coming before the chamber at a time when the accused is in better medical condition and for the formal procedure of reading the indictment and taking charges to take place. There are two issues. One is for the court to ascertain the attitude of the accused to the indictment, which is dealt with in subparagraph 3 of Rule 62. But there is another issue, and that is the issue of Your Honours being satisfied that the accused is aware of the charges against him. And that can be done in another way, which is to obtain an undertaking from counsel for the defence that at the very earliest possible opportunity he will make sure that the accused is fully acquainted with the terms of the indictment. And then, of course, Your Honours, if the case was to be adjourned on the basis that it can be brought on at any time before Your Honours, subject to Your Honours' convenience, at short notice, then any concerns that the accused may have about being incarcerated before a formal plea has been taken can be resolved by that process. And then we can only hope that the medical condition of the accused improves rapidly.
Bien,
Thank you. There were two concepts here. Mr. Todorović, or at least his counsel understood. First, there was the requirement that an accused cannot remain in an indictment before a trial chamber in a court, especially an international court. We have to keep in mind the concept of human rights. But he cannot remain in a detention facility either without having had initial appearance, which is what we're doing today. What the prosecutors just raised, Mr. Nešković, is that, in fact, we might postpone the plea of guilty, of the guilty pleas, but I do point out that if you've read the texts, that the accused can make no plea at all if he so chooses. And at that point, all his rights are guaranteed. Let me go to look at Rule 62.3, which says that we call upon the accused to enter a plea of guilty or not guilty on each count. Should the accused fail to do so, enter a plea of not guilty on the accused's behalf, which does not preclude if subsequently he would like to plead not guilty. We have already had examples of similar cases in other cases with which this trial chamber is familiar. A third point, the prosecutor has, in a sense, sent you back the ball. You have to know what it is that you want, Mr. Nešković. The judges here are very attentive to what you wish, but I think that you must speak with your client about this. We here cannot take an opinion from Mr. Todorović because he doesn't feel good. We are not in a tremendous hurry to have this initial appearance, but my colleagues and myself wanted to see Mr. Todorović today. Nonetheless, the prosecutor has provided an opening, and he has asked that not only one of the provisions of the text which has already been carried out is that you introduce yourself, but that you would read or have the indictment read to the accused. He was already read the indictment when he was arrested. Before I give the floor back to you, Mr. Nešković, I would like to turn to Mr. Todorović. I ask him to remain seated. At the time of your arrest, did they read the indictment to you? Please remain seated. Did they read the indictment to you?
Since I was in a very bad shape, they were showing me something, but I do not know what specifically. I do not know what they were reading to me. There were some papers there, but there was something on one page, but I don't know exactly what it was.
Thank you, Mr. Todorović. Then we can consider that at the time of your arrest, you were not conscious of what was being read to you. Let me now turn to Mr. Nešković. Since the arrest, and since you have been working on this case, did you have the opportunity of reading as you must do according to the rules of this tribunal, did you read the accused to the accused, and what impressions did you get from him? You must have felt something while you were reading it to him.
Mr. President, Your Honors, I have not at all examined the indictment with my client, nor have I discussed it with him. My first contact with him was yesterday, and we spent the whole time discussing his health. Please do not take me wrong. The initial appearance could take place tomorrow after a scan is taken of his head. I have said this out of caution, and the practice in this tribunal so far has shown that if the defendant doesn't feel well, we must request a full medical examination so that we know that he's fully conscious of where he is, of what the indictment says, and that he may enter a proper plea. I have not asked for any adjournment. I have just familiarized you with his state of health. I found him in his pajamas, the pajamas he was wearing when he was taken into custody in the Federal Republic Yugoslavia. I cannot go into the details of the procedure of his arrest. The tribunal could request such information from the appropriate unit of the SFOR. All that I am asking is that a scan be taken of his head to make sure that there is no hematoma inside, and then we can have an initial appearance, if necessary, tomorrow.
Just one moment, Mr. Neskos. Your request is actually official. I would like your request to be made official, that you would like this initial appearance to be postponed. We have to be very clear here and understand one another.
I'm proposing that we postpone the initial appearance because of the medical condition of Mr. Todorović, but in order to assist the trial chamber, I propose that we have the initial appearance as early as tomorrow if the examination is carried out.
You heard the request of the defense, who prefers that this initial appearance take place only after the MRI, if, in fact, the register orders that one be done. Do you agree with that, Mr. Neiman?
Yes, Your Honour, we agree with that. We think that's a sensible course.
Bien, je voudrais consulter.
I would like to consult with my colleagues.
Bien. Monsieur Todorović.
Mr. Todorović, please remain seated, and Mr. Neskowicz as well. First of all, Mr. Todorović, from the register, I have just received, or we have just received, a certain information about your medical condition, and do you agree, since the registry did do something, this is a public hearing, the registry has not ignored the situation, has not paid attention to it. Do you agree that I reveal what was done? Do you agree to my explaining what your medical condition is as of today, once the formalities that were taken by the the registry were carried out. Would you like to speak on behalf of your client, Mr. Neskovic? But I'm also going to ask your lawyer. In other words, what I want to say in public is that everything that was possible to do was done when Mr. Todorović arrived. Perhaps there are other things that can be done, but we haven't gotten to that point yet. For the time being, there are formalities that were carried out when Mr. Todorović arrived after his arrest. I would first like to ask you whether you agree to my revealing what was done.
Monsieur Todorović,
Mr. Todorović, do you agree to my revealing these things?
Your Honors, I must say that I was given some medical attention, but a visual examination cannot disclose whether there is anything behind those outside injuries.
Mr. Todorović, that's not the question I'm asking. I'm simply asking whether you agree to my revealing what was done by the efforts of the registry on the medical level. Do you agree or do you not agree to my stating what was done? Your counsel said yes, but I would like to have your opinion.
Monsieur Todorović.
Todorović?
Yes, Your Honor.
Il n'y a pas de grand secret.
This is not a great secret. I would simply like to point out the accused was seen by the physician at the detention unit who called in a neurologist for consultation who made a diagnosis of a hematoma and said that an MRI at this point was not necessary. I'm not saying that one should not be done. I'm not a physician. I simply wanted to make this clarification to the public, but with your authorization. Having made this clarification, the question which the judges must now respond to is whether or not to continue with this initial appearance. We would like to ask Mr. Todorović and his counsel, are you at least in condition to hear the reading of the indictment? We're not going to ask you to plead guilty or not guilty. We will simply note that you have entered a plea of not guilty. Are you in a condition which would allow you to hear the reading of this indictment? Since your counsel has not had the opportunity to read it to you, take your time. You may consult with one another if you want to consult with your client, Mr. Neskovic, and you can do it in private if you care to.
Bien. Monsieur Todorović.
Well, Mr. Todorović, are you in a condition to hear the indictment? And then we will enter a plea of not guilty. I'm not going to ask you to do what we do with all of the accused, that is to rise, but simply we'll in this public hearing, we will replace the reading of the indictment, which should have been done to you had you been in better condition yesterday. Do you agree that we read it?
Your Honor, if there may be a break so that I may consult with my counsel.
Alors,
Very well. We will suspend the hearing for 5 minutes.
All rise. Veuillez vous lever.